All right, everyone, welcome back to another deep dive. Today, we're going to be taking a look at employment agreements.
Ooh, yeah.
And we've got a whole bunch of research here that we're going to be going through. And it's more interesting than it sounds, I promise.
It really is.
And, whether you're an employee or an employer, I think this deep dive is going to be super relevant to you because it's all about understanding your rights and setting yourself up for success.
Absolutely.
So to kick things off, our sources define an employment agreement as basically a legally binding contract
Right.
that outlines like all the crucial details of the job, like everything.
Yeah.
But one thing that I found interesting is that even in those states that have that at-will employment thing, where you can technically quit or be fired at any time, like without any reason,
Right.
these agreements still carry a lot of weight.
Huge weight.
Yeah.
It's not just a formality.
So why is that?
Well, I think about it this way, like, you wouldn't buy a house without a super detailed contract.
Right.
Like outlining every single thing. An employment agreement is kind of like that for your work life.
Oh, okay.
It protects both sides. It lays out exactly what's expected from you and what you can expect from your employer.
That makes a lot more sense. So it's like a protection for everyone.
Exactly.
Okay, so I'm looking through all this research, and these agreements, they have a lot of different components.
Oh, yeah. They can be pretty dense.
Yeah, they cover everything from compensation and benefits to, like, job responsibilities, confidentiality, non-compete clauses.
There's a lot to unpack.
Yeah, where do we even start?
Well, I mean, the first thing I always tell people to look at is the compensation section, because let's face it, that's what everyone cares about, right?
Right, of course.
A good agreement should very clearly state your salary, how any bonuses will work, and like when you're getting paid.
Right.
And it can't just say like bonuses based on performance.
Yeah.
You need specifics, like how's that performance going to be measured? What are the actual targets? And then how much are those bonuses going to be?
Right, or else you don't even know what you're working for.
Exactly. It's like playing a game without knowing the rules.
Yeah, and what's so funny is I was talking to a friend the other day, and they were having this like disagreement with their employer over like bonus payouts.
Oh, no.
And it all boiled down to like the terms weren't clearly defined in the agreement.
Oh, that's so common.
And it's so frustrating.
I know. And it can lead to some like pretty serious disputes down the line.
And I was reading in one of the sources too about this case where this employee, they were promised a significant bonus if they hit certain sales targets, and they like totally crushed those targets.
Wow.
But then the company was like, well, your bonus isn't actually significant enough.
Oh, no.
And it ended up in this huge legal battle, and it's all because like that word significant wasn't defined in the agreement.
See, that's why clarity is so important.
Right.
You want to like avoid any room for interpretation or disagreement later on.
Oh, for sure.
And that actually brings us to another like super important piece of the puzzle, which is the job responsibility section.
Okay, so instead of it just saying like you'll be responsible for marketing activities, it would actually outline each activity in detail.
Right.
Okay.
Because a vague description could mean anything.
Oh, yeah, for sure.
You really want to know like what your role actually entails, what projects you'll be working on, who you report to, and like what level of authority you have.
So it's like you're saying it's almost like building a puzzle and every single piece is in the right place and it makes this picture
Exactly.
of the working relationship.
A clear picture.
Right. What about things like work schedule and location? Because I feel like that's pretty important to people.
Yeah, that's a huge one these days, especially with, remote work becoming so common.
Yeah.
The agreement needs to specify if it's a remote position, if it's in office like full time.
And if it is a hybrid, like how many days a week are you expected to be in the office?
Exactly. And like what kind of flexibility is there, if any?
Right.
These details can really prevent headaches down the road, especially if like, your preferences change or the company's policies change. It's always better to have it all in writing from the get-go.
Okay, so we've covered compensation, job responsibilities, work schedule, location. Is there anything else big that I'm missing?
Well, there's one more big one that we should definitely talk about, which is confidentiality and those non-compete clauses.
Oh, yeah, those are important.
Yeah. So basically a confidentiality clause states that, you can't share any sensitive company information, whether it's about, their clients, their internal operations, their like trade secrets.
Okay, that makes sense.
It protects the company's competitive advantage.
Right.
Now, non-competes, on the other hand, those can get a little bit trickier.
Yeah, I've heard they can be pretty strict.
They can be, basically, they aim to prevent you from, going to work for a competitor or starting your own competing business
Oh, okay.
for a certain period of time after you leave the company.
So let's say I worked for a tech company and I signed a non-compete. Does that mean that I can't work for another tech company in that same field for like a year or two?
Yeah, that's exactly what it could mean.
Yeah.
It really depends on the specific terms of the agreement, but the whole idea is to protect the company's interests and prevent you from taking your knowledge and skills straight to a competitor.
Oh, okay. Yeah. So I can see how that would be important for some companies.
Yeah, especially in those like really competitive industries.
But do these non-compete clauses ever like go too far?
Oh, yeah, absolutely.
Because I've heard some horror stories about people being blocked from working in their field for years.
Yeah, and that's where it gets interesting. Like there's this whole debate about what makes a non-compete clause actually reasonable.
Okay, so what is reasonable then?
Well, it depends. A few things come into play.
Okay.
The courts typically, they'll consider the duration of the restriction. So like how long you're actually barred from working.
Okay.
And the geographic scope. So like, is it just in your city, your state, the whole country?
Oh.
And then also the specific activities that are actually prohibited.
Okay, so like, are there any specific examples that would be considered unreasonable?
Yeah, so let's say a non-compete prevents you from working in that same industry anywhere in the world for 10 years.
Wow.
That would most likely be seen as unreasonable.
Yeah.
Because it's way too broad. The courts, they're more likely to uphold those non-competes that are narrowly tailored to protect like the company's legitimate business interests without totally restricting the employee's ability to earn a living.
Okay, so it sounds like it's all about finding that balance
Yeah.
between protecting the company and the employee's right to work.
Exactly.
So we've talked about compensation, job responsibilities, work schedule, location, those non-compete and confidentiality clauses. Are there any other major components that we should be thinking about?
I think one of the most important things to keep in mind when you're looking at any employment agreement is that it's more than just a formality.
Oh, for sure.
It's a real roadmap for that working relationship.
Yeah.
A well-drafted agreement protects both sides.
Right.
For employees, it gives you that clarity about expectations, and it can help prevent those nasty surprises down the road. And for employers, it safeguards their interests and minimizes that risk of getting into disputes.
So it's like a win-win for everyone.
Ideally, yes.
Okay, well, let's be honest. Most people don't exactly jump for joy at the thought of reading through like pages of legal jargon.
Yeah, it's not exactly light reading.
What are some like common pitfalls that we should be looking out for?
But one of the biggest mistakes that I see over and over again is people using really vague language.
Okay.
They think a general statement is good enough, but that can really come back to bite you later.
Can you give us an example of that?
Sure. So imagine an agreement that says an employee is entitled to a reasonable number of sick days.
Okay.
Well, what does reasonable even mean?
Right.
It's totally open to interpretation. And that can create a lot of conflict if the employee and employer have very different ideas of what reasonable actually looks like.
So instead of saying reasonable, it should actually specify the number of sick days.
Exactly. No room for ambiguity there.
I like that.
Or let's say the agreement mentions a bonus that's based on satisfactory performance.
Right.
Well, what is satisfactory, without clear metrics and targets? It's just asking for trouble.
So basically be as specific as possible.
Yes. Specificity is key.
Okay, good to know.
Another common pitfall I see is not outlining the process for performance reviews very clearly.
Oh, right.
Like when are they going to happen? Who's going to conduct them? What criteria are being used to evaluate performance?
Because that all ties into like raises and promotions too, right?
Exactly. So it's crucial to have a clear understanding of how that process actually works.
So we've got vague language, unclear performance review processes. Is there anything else?
Well, we also want to look at termination clauses.
Okay.
So these outline how that employment relationship can be ended by both the employer and the employee.
So things like notice periods, severance, pay grounds for termination.
Exactly. It's important to be super clear about what happens if one side wants to end the agreement, whether it's, voluntary resignation, layoff, performance issues, whatever it is.
I was reading this one case where an employee was let go with absolutely no warning and they didn't get the severance pay they were entitled to.
Yeah, that's brutal.
It happens more often than you think.
It does, and that's why having those details clearly laid out in the agreement is so important.
Right, it protects both sides.
Exactly. Now, another thing that often gets overlooked is dispute resolution.
Okay, what is that?
So this section basically outlines how disagreements or conflicts will be handled between the employer and employee.
Right, because you don't want it to end up in some long, drawn-out legal battle.
Exactly. A well-drafted agreement will have a clear process for resolving those disputes, whether it's through mediation, arbitration, some other form of alternative dispute resolution.
So it's like a safety net.
Yeah, exactly. It provides a structured way to address those disagreements and hopefully reach a solution without, having to go to court.
Now, when we were talking about non-compete clauses earlier, I remember reading in one of the sources that some states have laws that actually limit how restrictive those clauses can be.
That's right. Employment laws, they vary a lot from state to state.
So it's not a one-size-fits-all situation.
No, you really need to tailor the agreement to the specific laws in your location.
Okay, so what's the best way to make sure you're complying with those laws?
Well, this is where seeking legal counsel can be really valuable.
Okay.
An experienced employment lawyer can help you navigate those complexities and make sure your agreement is, airtight.
I was just going to ask about that. Do you think it's always necessary to hire a lawyer for every single employment agreement?
I understand the concern about costs. Lawyer fees can add up.
Yeah.
But I honestly see it as an investment.
Okay.
A well-drafted agreement that's been reviewed by a legal professional can prevent so many costly disputes and legal battles later on.
That's true. It's better to be safe than sorry.
Exactly. An ounce of prevention is worth a pound of cure. Sure. And, it's not just about avoiding legal issues. It's also about making sure both parties' interests are fairly represented.
Okay.
A lawyer can help you create that balanced and legally sound document that protects everyone involved.
So even if you're using like a template online or something, it's still a good idea to have a lawyer look it over.
Absolutely. They can catch those hidden clauses or those potential pitfalls that you might miss on your own.
Like a second set of eyes.
Exactly. Now, beyond all the legal stuff, we also need to talk about the importance of communication and transparency throughout this whole process.
Oh, yeah, that's a good point.
It's not just about the document itself. It's about how it's presented and discussed.
Right.
Both the employer and employee, they should have a chance to review the agreement, ask questions, get clarification on anything that's unclear.
It's two-way street.
Exactly.
Yeah.
You want to make sure everyone is truly on the same page.
Right.
And that open communication can help build trust and foster a much more positive working relationship right from the start.
I love that approach because it really is about building that foundation for a good working relationship.
Yeah, it sets the stage for that positive and productive work environment.
So we've covered so much, from the key components of an employment agreement to common mistakes to avoid. I want to make sure our listeners are leaving with some key takeaways. If they could only remember a few things from this deep dive, what would those be?
Oh, man, there's so much good stuff here.
Yeah, there is.
But I think if I had to pick like the top takeaways, I'd say the first one is just realizing that an employment agreement isn't just some random piece of paper.
Right.
It's a legally binding document.
Yeah.
It can have a huge impact on your working life. So whether you're the employee or the employer, you got to treat it with the seriousness it deserves.
Right. Don't just like skim through it and sign it without really understanding what it all means.
Exactly. And that actually leads into my second big takeaway, which is all about clarity and specificity.
Oh, yeah. We talked about that a lot.
Yeah. Vague language can really come back to bite you. So make sure all the important terms, everything from how you get paid to what your job actually is super clear.
No room for misinterpretations.
No. And if something seems unclear or like you're not sure what it means, don't be afraid to ask questions.
Yes, good point.
It's so much better to clarify up front than to deal with confusion and conflict later on.
Oh, yeah, for sure.
Okay, so my third takeaway would be you got to be aware of your local laws and regulations.
Right.
Because employment laws, they can change like crazy from state to state.
Oh, yeah, for sure.
What's legal in one place might not be legal in another. So do your research.
Yeah.
Or even better, talk to an employment lawyer just to make sure that your agreement is following all the rules.
They're like the experts, right?
Exactly. They know all the ins and outs.
Okay, so final takeaway.
All right, my last one. This is a big one. Remember that getting legal counsel can be a really smart investment.
Right.
An employment lawyer can help you with all those tricky parts of these agreements. And they can protect your interests and make sure everything is actually legal and above board.
It's like having a guide through the legal jungle.
Exactly. Someone to help you avoid those hidden traps and make sure you're on solid ground.
Okay, so whether you're like starting your own business and hiring your first employee or you're, thinking about taking a new job, don't underestimate how important that employment agreement is.
It's the foundation for a good working relationship.
Now, before we wrap up, I'm curious, one of our sources mentioned the whole rise of remote work and the gig economy.
Oh, yeah.
And it made me think, how do you think those trends are going to shape the future of these agreements?
That's a great question. It's something I think about a lot because those traditional employment agreements, they were designed for a very different world.
Right, like when everyone worked 9 to 5 in an office.
Exactly.
Yeah.
But now we're seeing this huge shift towards more flexible work arrangements.
Yeah, like freelancing and all that stuff.
Right, and that raises all sorts of new questions about, like, how do we define job responsibilities?
Right.
How do we handle intellectual property? And how do we make sure everyone's complying with the laws?
So it's like the old rules don't really apply anymore.
Not always.
Yeah.
We're already seeing new types of agreements popping up, like freelance contracts and statements of work that are more suited to this new way of working.
So the laws are having to adapt to.
Yeah, it's a constantly evolving landscape.
So much to think about.
It is. But the most important thing is to stay informed, seek expert advice when you need it, and just be willing to adapt, as the world of work changes.
Well, I think that's a great place to wrap things up.
Yeah.
Thank you so much for joining us for another deep dive.
My pleasure.
I hope you found this journey as insightful as we did, and we'll catch you next time.
See you then.
If this podcast helped you, don't forget to like, comment, and subscribe. Your support helps us keep making these videos. Thanks for watching.